to know what the order of proceeding is when it comes to going to court, and you see these court cases on television where each side gets their chance to present their side to the judge. Having said that, let me explain what happened. Well, let me just review it like this. Typically, a person, whether it's a lawyer or a person representing themselves, they walk into court, the proceeding starts. The person is prosecuting the case, the plaintiff or a petitioner, will start out by basically an opening statement. They'll basically run down what their case is about. They talk about the evidence they have. They'll merge the evidence into the facts that they're trying to get established by the judge. After they do that, if they have any testimony, if they want to testify on their own behalf, or if they want to bring a witness or call a witness to testify, they do that. That part of it is called the testimonial evidence of the proceeding. And that goes with the physical evidence that you may have or documents you may have. And you put all that together. And that's basically how you do your case. And then at the end of your presentation, the other side gets a chance to what they call rebuttal. They challenge things that you present, evidence you present, and then they bring their own evidence. Now, typically at the end of all that, the person who started it off, the plaintiff, gets a chance to have the last word by rebuttal. Now, having said that, our experience was totally different. We went to court. I stood up to present my case. I got about 2 sentences in before the judge stopped me and started to say, well, now here are the real issues. And at that point, the judge announced that the precipient witness, the main witness that I was going to elicit sworn testimony, the judge stopped me from doing it. And she said, I don't see any need to put you under oath. Why don't you just tell us what happened? Now, this person was a lawyer who was at the mediation proceeding. It was my intent to elicit testimony under oath from that lawyer as to what really happened at the proceeding. The issue was, we argued that the mediator never looked at the documents produced by the bank to show they owned our note. We never got there. We got in a debate prior to that, and we never got there. Now, that's what my petition states. All I wanted to do is put that lawyer on the stand, ask him some questions under oath to establish what the petition already said, that the mediator never looked at the document. And the judge knew this. Now, the reason the judge knew it is because a week before the hearing, I sent a letter to the counsel in question, and I told him precisely the questions I was going to ask him under oath when he got on the stand. Now, apparently, and there were some damaging questions, very revealing. Apparently, he called the judge and said, you need to figure out how to keep me off the stand because I don't want to have to testify under oath. And that's exactly what she did.
Doesn't that prove ex parte communication?
Yes, it does.
Right. Mm-hmm.
And so when that got, in lieu of allowing or requiring the attorney to get on the stand, she posed a series of leading questions to the counsel. Said, this is all we really want to know from you. Isn't it true that the parties met? Yes. Isn't it true that they had a discussion? Now, she wanted to stop it right there. So I said, well, if he's not going to be under oath, and I said that I was very aggressive. I thought I was going to go to jail. But I was very aggressive, and I said, well, wait a minute. If he's going to talk about that, the mediation proceeding, he needs to be under oath.
For the record, but they don't want a record.
Yeah, so he was allowed to answer her leading questions. But when it got to the point where the issue was the question regarding whether the mediator saw our documents or looked at them, she stopped him. And so I proceeded to plug that part of it in. But here's the problem. When you talk about, our case has went on for 6 years. We've had 2 mediations, all kind of everything. We were duplicating what we had done in 2010. Mediation proceeding, petition for review. So it was going to take me a minute or two to finish my case. She shut that case. As soon as she finished with the leading question, she terminated proceedings. Now, I had several other issues that I wanted to present in that, for the record. Never got a chance to do it. And so now I'm going to show you how tacky sometimes things can happen. We go home. Just before the hearing terminated, the judge first the judge denied our petition. She then instructed opposing counsel, representing Chase, to prepare the order for her to sign. She also told counsel that she ordered that a transcript be prepared for the hearing and sent to counsel to assist him in making the final order. Now, I'll talk about it in a minute. So after she did that, we go home. I had the transcriber, the court reporter emails me and tells me that it's going to cost me $200 for the transcript. I email her back and say, well, that would have been if the court hadn't ordered the transcript and if the transcript wasn't going to be used to assist counsel in drafting the order. So my position was I would like to have the same transcript. He serves me the transcript with proof of service that he's going to use to make the order. I don't want her generating two different transcripts. And so that's where we left it off. So the bottom line is we now have to wait. I remember what the judge said. The judge ordered that after he gets the transcript, he was supposed to send us a copy along with the proposed order, like they do in Nevada. And the court reporter said, well, this is my work product, and I get $200 for this. And I'm telling her, if you have to produce the transcript anyway, by order of the court, why would I have to pay for it? But I told her I wasn't trying to save. I just want the same document that counsel uses to draft it. I want a copy of the same document. Now, the other thing, and I'll say this, and then when you go into general stuff, the court reporter should be. The reporter's responsibility is to objectively report a proceeding. If a reporter comes from a pool, then it's not the same. There's no duty of the court reporter to do anything. Right now, we have to wait.
As part of the order, apparently, that's the way. Off the transcript.
That's true.
So, I mean, it's stacked.
Unfortunately, of racketeering. Now, because of the scheme that was involved in the whole process,
Racketeering is a scheme.
it's a scheme, and what she was doing was upholding what the mediation proceeding produced. And our argument, and it's even in my petition, is that all of that process was in furtherance of being repeated and has been for years. And basically what it is this. The problem is Chase Bank doesn't own the note. Washington Mutual mutual note that Chase claims that they got from the FDIC, it's not true. They couldn't have gotten it from for a lot of reasons. But notwithstanding the reasons, we can debate all day long. All we ask is that we ordered a right to a fair administrative hearing and a fair court proceeding hearing, and if we had a, we by the evidence that Chase never got the note from the
What's the status on the transcript?
well, because sometimes I get focused. Basically, what she says is, "Why are you late?"
Record of the scheme.
It is, but it's also. But here's the thing. Ironically, it's so many factors that play into why we're right and Chase and the courts are wrong. One of them is this, and I'm talking to all Washington Mutual borrowers who got when it closed Washington Mutual. Under federal law, we could not have went to mediation. We could not have went to any court regarding complaint about the note or how it was enforced or otherwise. Under the 12 U.S.C. 1821D, under that statute, to the Federal Deposit Insurance Corp does not allow courts to Washington Mutual people in our shoes can make is that if they know they're doing it in violation, they know that the homeowner remedy is before the FDIC. Justices of the Nevada Supreme Court and coming from the FDIC, they're convicted to fraudulently induce the that is the only you call it ulterior motive. The state of Nevada, through their mediation, to convene a mediation a foreclosure certificate. That is what is called extortion. It's state-sponsored extortion. Claim.
It would be hard to prove extortion. They paid for your individual note. What are the chances of getting anything like that? Where did Chase pay? They paid the you owe me money, I loaned you money. into a negotiation down the road because my interest rate is now way too high. The market's been adjusted. So that what I'm trying to know.
That's the word now. See, Chase never paid anything. Marcy Mutual. Now, this is what happened. I think I talked about this last week or week before that. During this mortgage collapse in 2005, 2006, when the mortgage industry and banks went through, there was a scheme by Washington Mutual Bank America. Notes and shipping them out as quick as in increments of maybe 1,000, 2,000.
Yep.
Notes became a security instrument. Interest in it.
And Washington Mutual got the money.
He is to places and parts unknown.
Yeah.
Now, there's, I mean, some people heard of him and some people haven't. And 100,000 notes. That was directly proportionate to whether all the folks inside that thing that had notes were paying their monthly mortgage. A whole lot of them wasn't. A lot of those notes to invest in that package, that thing with all those notes, was it that sold the interest in that package, also sold was insurance. The insurance, in other words, they would go to a 401 or a pension plan, say, listen, mortgages, you'll be getting an income. But it's always possible, because a lot of people inside this note will default on their loan, on their mortgage payment, and not yield enough to pay you. So this is what we're going to do. We're going to sell you not only a portion of that package with all those notes, we are going to sell you some insurance in case it collapses. Your insurance will cover. And you won't lose anything. AIG was the main company that sold these mortgages. But what happened is, sure enough, enough of those mortgage notes collapsed. Package collapsed. AIG had to in case it collapsed, and that's what made the industry collapse. But here's what an individual situation like my wife and I, our mortgage note, which was from time, by the way, we paid performing notes with non-performing notes, and lapse, that all the notes inside there, performing and otherwise, were non. Those notes, including ours, to this I can't go after the evidence. I know how to do it, but I don't have the. When Jamie Fisher said, you know what? He says, we are aware of scores of. We would like, with the deal, that you. Washington Mutual got paid for them. They're in mortgage purgatory. Break them and enforce them. We're not going to allow you to enforce notes that we had no access to because they were gone. This is the FDIC talking to Jamie Dimon. We want. Did you really get the note from the FDIC? The FDIC told Jamie Dimon, we will not. That you're lying about the notes. We'll just act like no speculation, but the reason it's not total speculation is because I have reached out to the FDIC personally by letters and telephone calls, and the bottom line, it was the FDIC's position that even though Chase's claim, the FDIC sold a note to Chase, the FDIC's position is we verify it, repudiate it, and we won't support it. We have nothing to. If you want anything from us, you have to get a subpoena. Now, isn't that funny? He sells an asset, and then when the homeowner comes to the institution, they say, well, we can't verify what we think. It's like the FDIC taking the Fifth Amendment. You see.
Like the U.S. government taking the Fifth Amendment.
So that's where we are today, and so all we don't. And the irony of it is, ask yourself this question, because I've been accused by Chase attorneys of just trying to get out of paying a mortgage note. But ask yourself this question: if you were seated in your house, and all of a sudden one day, a fly-by-night mortgage company representative knocks on your door and says, from now on, pay us. You know, your mortgage payment you're paying, or who you're paying to, start paying us. We don't have any proof, but you better pay us anyway, or we'll foreclose. The question is, in America, would you acquiesce or subordinate yourself to a company, even no matter how prestigious, if you know that you don't owe that company any money? See, and that's the irony. We know that we don't. After 6 years of this and going through all these evidence and all that, we know for sure that if our mortgage payment is due, but it's not due to Chase Bank. We know about the scheme. We've done everything we can. And the bottom line is, if we owe Chase Bank, do you really think we would be 6 years without paying a mortgage note? And which is the case. We haven't made a mortgage note since 2009.
And still in the house.
And still in the house. And been through 2 notices. Now, these default notices that they have served us with, for reasons only known to them, they identifying Washington Mutual as the bank foreclosing. And the last notice we got was in 2014. They're still identifying Washington Mutual. Washington Mutual Bank's been closed for 7 years. And so when I wrote, now, Fortunately, the Civil Rights Division of the Department of Justice sent me a letter saying they will investigate our claim finally. Our claims have also been presented to the Ninth Circuit Court of Appeal for the justices up there to investigate it also because of the federal crimes that are involved. Anybody that goes to the internet, look up 18 U.S.C. 4. And that's called misprision of a felony. And that's a statute that says that anybody becomes aware of a that constitutes a felony cognizable in federal court has a duty to a judge or an official of the United States government. The reason our complaint is before the Ninth, by the way, as a response to the letter report. Now, because of the Supreme Court justices and judges of the Nevada District Court are involved, the Department of Justice sent the complaint to a higher authority than simply a federal district judge. They sent our complaint to the Ninth Circuit because of their supervisory role. We're still looking for people who are similarly situated that have Washington Mutual notes that.
Is there anyone out there that paid Chase off, let's say, and got a deed on their property? And how is their deed any good?
Well,
or have you ever found anyone like that?
Somebody told me yesterday what they do. Oh, this is what they do, because we thought about that too. Now, what happens to when a homeowner is so intimidated, even though the chain of title is broken, because Chase doesn't really have the document, they not even record it. What happens when a homeowner, though, that goes through the mediation or gets subjected to a default note, they give up and walk away from their house for fear of being foreclosed, because nobody want to be in the house when the marshal get there from a foreclosure. So what happens? Well, there's assortment of things that I guess happened, but one of the things somebody told me the other day, and I got to thinking about it, and I said, doggone, that might be what's going on. In Nevada, in most states, most jurisdictions, they have what's called what is it, an adverse condemnation. What is it? Well, anyway, I'll think of the term in a minute, but what happens is that if you abandon your house or you allow somebody to occupy your house for 5 years and they pay the taxes, what do they call it?
Adverse possession.
Adverse
It's
possession.
like 20 years, not 5 years.
Well, no, they got a 5-year one. What's
Yeah,
that?
5 year.
They got a 5 one in California, and I'm sure they have one here. If you let somebody reside open, they call it open and notorious occupation of your property, and you do nothing about it. I
They
think
pay
it's
your mortgage for 5 years.
Well, they don't have to do that. If, for instance, say if Chase, I leave the house, Chase bring their agents in, they occupy the house for 5 years, they pay the taxes for 5 years.
Just the
then
taxes.
they can do a petition to take control of that house. Now, it's Chase Bank. This scheme is well thought out by Chase. There's a company in Florida called Home Sales Incorporated. Home Sales is an affiliate of Chase Bank. They have employees in Florida and they have employees in Ohio. And their job is to property manage the houses that Chase steals. And that includes acting like a property manager, getting insurance for the property, and anything else it has to do with managing that property. Even before Chase, for instance, our house is being managed by Home Sales as far as what Chase thinks the interest they have in our house, which is none, but it's a contest. We're
So
fighting.
who gives title? At the end of the day, at the end of the 5 years, who gives title?
In the court order, Chase can go, and anybody else. If you occupy that, you say it may be 20, but I think it's 5. At the end of 5 years, all you have it's just like a quiet title action. Basically, that's what it is. A Chase Bank representative does a quiet title action under the, what do y'all call it? Adverse
possession.
Yeah, adverse possession. They do, and once the court gives them that judgment, record that, and you can move forward owning the house.
What's the court? State, federal?
It's a state issue, state court.
Right. So because it's more or less a federal issue in a way. How does a state has to give title to property? That's the only one that can.
Right.
But where does the authority come from when the FDIC and all this stuff has been so convoluted? How do you get clear title is what I'm trying to figure out. Is where, if someone ever questioned that, how would a new buyer, if they do a title search, how in the hell would a new buyer in all consciousness say, well, that's good, just because it came from the court in the state and it's an adverse title or whatever it is? I mean, I don't know. You probably haven't looked into this enough because you're not at this point yet. I mean,
Yeah, I've looked into that too.
Have you?
You see, everybody's heard of title insurance.
All right.
And if anybody that borrows money, if it's not 20% equity remaining after you get the loan, you got to get PMI.
Right.
And that before you get PMI, the PMI companies go to the title insurance and say, look, will you insure this? Will you insure title as represented by the seller? Right. And if the title insurance does, and the title insurance will, if there's a judgment sitting there saying that this property's been conveyed to Chase Bank under an adverse possession statute, whatever. Now, so that's how now somebody just told me that the other day. And I said, oh, because before that I was speculating all day long. One of the things I thought was happening is I thought that we haven't found any homeowner who has waited and been subjected to a notice of trustee sale at the end of all this, as the normal termination of this kind of thing. We haven't seen it. What we think is happening is typically a homeowner gets a default notice. Chase is fraudulently trying to take over their note. They either go to mediation or they just wait and do nothing. Chase then goes and do a notice of trustee sale and sell their property.
Or the homeowner is taking the modification when they go to mediation, and they don't want to lose their home. They don't want to fight. All they want to do is stay in their house, so they will accept a modification, knowing that the modification is not coming from the lender that they borrowed the money from, but they're still in their home and they're paying a house note. We have a friend that did that.
Right, but do they have any confidence they'll ever end up with a clear title?
They don't worry about that. They just want to stay in their house because they're going to be in there for 30 years. And you're going to be for 30 years anyway. So at the end of the day, hopefully, but you don't know. You know, who pays their house off really? How many people do you know have paid their houses off? They've got to be in their 60s or 70s when they do it. My mother-in-law's in her 90s. Her house is going to be paid off next year. Okay, yeah. And she was with Chase. She was with Washington
These people
Mutual.
Look at it like the alternatives pay rent somewhere, so what's the difference?
Yeah, you're going to pay rent, so you might as well pay. But you know, you got a house.
Right.
Because her note was with Washington Mutual. And then she received one of those letters from Chase saying that they had taken over. But she chose not to fight. You know, she just paying her house note. And she's been doing it the whole time we've been doing ours, so 9 years. So at the end of, when you finish paying, usually you leave the house to somebody else. Do they sell it? Do they try to borrow money on it or whatever? You know, you don't know. Most people just pay their note, and if they do have any equity in it, they try to make a loan on it.
And see, this is a crime, a scheme that can easily be impacted and corrected.
Because a lot of people and entities have made money off of this scheme.
Yeah.
So that's the crime. I mean, all these derivatives and all these packages and bundles and all these changed hands and money. So that's the despicable part of it. And it's going to take a class action lawsuit against the federal government
It's going to take more
to
than
get
that.
it straightened out, because the federal government's going to have to be responsible for this. You're going to have to get Barney Frank off his porch.
Well, you know, Barney Frank is a help. But what I'm saying is the federal government knows what's going on. They know it.
Well, you know, the comptroller of the currency, anybody keeps up with this stuff, the comptroller of the currency did an action against the major lenders for mortgage servicer irregularities and fraud and the whole thing. And literally, they allowed, the government allowed itself to be bribed. And what happened is they came up with a settlement.
Yeah, to the OCC.
Yeah, and so the banks paid huge amounts of money to the OCC in exchange for not going any further in terms of criminal investigation.
The OCC is just a protection racket.
They,
Right.
Yeah, they just paid off that, and they left us homeowners in the same shape we was in before the payoff.
You're
What
supposed
is-
to have repercussions if someone enforces something, but in this case, you didn't have enforcement because you had a protection organization that only works for the banks.
That's right. That's why. What's
They
this?
get paid by the banks
Yes.
every year to be part of the OCC.
Right.
So it's like buying off the mafia, and the mafia then protects you.
Right.
Well,
Now, what's
who's over the mafia?
But what's the senator in? What's her name? She took. You know. Who
You
I'm
know what
talking
we're
about.
talking about.
Hillary Clinton.
No, not Hillary.
No,
no,
they-
no, no, no.
This was
Go Hillary. Go Hillary.
She
what's
was
her
the
name?
one that they wanted to run.
Warren.
Elizabeth Warren.
Elizabeth Warren.
Okay.
See, she's trying to.
Indian.
Now she says she's not an Indian. She's part
Oh.
just like we're part white. You probably
Right.
part black. But what I'm saying is, she knows what's going on, but she can't get anything done because everything is so corrupt.
Well, you
Well,
know
She
that's
that.
a
knows
huge
that the banks.
corruption, there's no
She
doubt about it. It's
knows
probably
that the
one of the
banks are
biggest
at
ones.
fault. But
Yeah,
yet,
this is a
still,
huge.
the banks they settled. They made a settlement.
Yeah, with who?
And the government.
No, the OCC.
No, but that's
I'm gonna
part
tell
of the
y'all
government.
something.
That's the government.
This is one of my complaints about Obama. This is one of the things. You know, I'm an Obama fan and voted for him, and even did poll watching and all that. But for some reason, only known to him and Holder, in the course of enforcing laws and doing what they do, they left the banks entirely alone to let them do as they saw fit.
Like she says, nobody's going to jail.
They never now Loretta Lynch. My wife told me this. Loretta Lynch said the other day that her legacy, when she leaves that office, is that people say that she helped people. See, the Nevada Attorney General, the United States Attorney for the District of Nevada, and all these officials will not entertain a complaint from a single homeowner. If it's not class action kind of stuff or something major, I have formally complained about this to the United States Attorney, District of Nevada, the Nevada Attorney General. I sent him a formal complaint last year.
And we
They
met
won't
with-
touch
yeah.
our complaint with a 10-foot pole. They will not touch it.
We met with Mastro and Bo Biden when they were out here 3 years ago, and they know what's going on.
Bo Biden done. He's going.
He
went on to
knew
heaven.
then, but
Before
rest
he
in
went to
peace.
heaven, he knew.
Yeah.
What was with the suits that were going on with all the attorney generals gathered together?
That's what I'm talking about. Yeah.
Precisely what we're talking about.
Yeah,
Yeah.
and they made extortion, if you will, to have these mortgage companies settle with them. And one company made beefs over Maestro or something, not doing something. They got $1 million judgment from Elizabeth Gonzalez here, or an order from the judge that Maestro or the us taxpayers of Nevada have to pay that mortgage company their legal fees back, which occurred to like $1 million. That just happened not too long ago.
I haven't heard about that, but,
But this is all linked together. The settlements that were made with these attorney generals, it's like a smoking thing.
Yeah.
Yeah.
There was money there, so all the attorney generals trying to make money jumped all together into this thing. But it was all phony, I guess, because what's straightened out? Nothing.
nope.
The rationale that's imparted to the powers that be that's supposed to do something about this stuff, the rationale is, well, homeowner, you may not be paying the right bank, but you do owe the money. You just soon pay Chase Bank as anybody else. It ain't like we're stealing anything from you.
Well, but you have, I don't want to muddy the waters, but there's a thing called like negotiation, that when there were a lot of mortgages that were made when junk bonds and so forth were going around and interest rates were extremely high, and if you made a deal to have a mortgage or buy a building or what have you, and you had a junk bond, at some point when the market collapsed, you had the right to negotiate that junk bond, or you were going to bankrupt and walk away, and whoever you owed the money to was stuck to a certain amount, so you renegotiated. Well, somehow, whatever renegotiation you had available to you has been stolen from you. Because if you're in this pool with good loans and bad loans, shouldn't you have been adjusted somewhat to be a good loan and maintained to be a good loan? You got robbed of that negotiation.
Well, you know what we received from Chase last year, a modification contract naming Chase as the lender
Right.
for us, and they were going to modify our home loan down to like $1,800 a month.
But you know, you guys, this is the scary thing about this. Peel the what do you call it? Take the peel from the onion. Well, what's that term? Anyway, you peel the whatever from the onion, and this is what you find in the Chase FDIC scenario. The series of judgments, affirmed judgments, has ended up. Chase Bank has been put in a position with regards to those Washington Mutual notes of not having to provide or produce any proof whatsoever. Their attorneys are now empowered to walk into court and say, we own the note, we don't have any proof. The judges will turn around and say, you don't need any. It's really happening. It happened to me.
You said that before.
It happened to me on the 24th. The judge looked at us, and the last thing she said, Chase doesn't require any writing. Because our note was part of, this is what the Nevada Supreme Court is directing them to say, which is illegal, but the Nevada Supreme Court has phrased it like this. Because your note was part of a large-scale acquisition from the FDIC, no writing is required regarding the individual note. Now, that when they say that, they just make that statement. It sounds good, but when you look at the statute that they rely on to support that statement, the federal statute doesn't say that. It doesn't nowhere near say that individual notes. Nevada has what's called the statute of frauds. That's NRS 111-205. The statute of frauds said that land and security interests thereof, when it's transferred, it has to be by a writing. Now, that federal statute doesn't preempt that. The only way that federal statute can preempt that is that it would, under federal case law, that federal statute had to be specific that is preempting that state law. Basically, how the two laws get along, the state and federal, the statute of frauds and the law that governs the FDIC takeover of a bank are compatible. The federal law says the FDIC can take over a bank and transfer its assets to itself without permission, assignment, or anything. State law says yes, but when the FDIC gets ready to sell one of the notes to an acquiring bank in Nevada, the statute of frauds kicks in, and the FDIC is required to transfer that note to Chase Bank by a writing. The federal statute doesn't preempt that. Under the preemption doctrine, and I talked.
Property is local.
Yeah. So the preemption and the supremacy clause, they call it the preemption doctrine, but the supremacy clause basically says that the Constitution and federal statute is the supreme law of the land, and any conflict with state law has to be decided in under the federal law, unless the state law doesn't interfere with the federal. If it's shown that the state law is compatible or doesn't interfere, state law holds. Well, the Nevada Supreme Court has forged some case law to preempt that. And what makes it so bad, the Nevada Supreme Court in a prior decision upheld the preemption doctrine. Now they reversed it for purposes of allowing Chase to lay roughshod over notes that are held by Chase Bank, or that ended up in Chase Bank. So that's called the manipulation of the law. Now the fallout from that is that all the homeowners that go to court fighting Chase, the judge is looking at the homeowner saying, Chase claims your note and Chase doesn't need proof. Now you prove that they don't. Tell the homeowner that they're charging the homeowner with the burden of proof that Chase didn't own their note in the same courtroom where the judge is saying Chase doesn't need any proof in America. under the Fifth Amendment, no way that no company.
Well, you take the right to property rights under Article 14 and 1983 action and due process and possession. You have possession of that house. So how do they take it away from you when you have your rights as property and you have possession? They still have a big hump to get over there, but it's going to take something that's magnanimous to be able to straighten this mess out, because it's one of the worst things I've ever heard of.
Tune in again next week, because at risk of the wrath of the Nevada bar, I just filed a federal action on behalf of a homeowner in the same shape I'm in. The Chase Bank attorneys filed a motion to dismiss. We filed, in the meantime, a preliminary injunction to enjoin them from selling her house. We understand that the district judge denied yesterday the injunction, but I'm optimistic. This is where we are. The homeowner claims or refutes Chase's claim of having gotten her note from the FDIC. So, and if Chase Bank shows up in federal court saying that's where they got the note. If Chase Bank got the note from the FDIC, the federal statute requires the federal judge to dismiss the case. The judge can't take jurisdiction of the case. The judge has to dismiss the case in favor of the FDIC administrative claims process. Under that federal law, she can't come to district court. She has to go to the FDIC with her claim. Her argument in federal court is, federal court, I understand about that, but Chase didn't get the note from FDIC. That's why I'm here. Chase Bank is coming into federal court saying, no, we got the note from the FDIC, but we have no explanation why we're here. Well, now it's on the judge's desk to decide whether he believes her. If he believes that the note didn't come from the FDIC, then under law he has to go ahead and do the lawsuit. But if the judge decides that the note came from the FDIC, he has to dismiss the case in favor of the FDIC, but at the same time he's doing it, well, that's what he has to do. Now, under that federal statute, when he dismisses the case, she goes to the FDIC with her claim that she had in federal court. Now she got to go to FDIC. And if she don't like that result, then that federal statute says, then and only then can she come back to federal court and with her claim. But she got to go through the administrative process first. We're thinking that the judge is going to divest himself of jurisdiction, require Chase to go to the FDIC. By law, the FDIC got to come to court and tell the judge, you got to dismiss this case. She has to come to us. Now, what's so interesting, and I'm glad that her case is the one that's testing this, is that her issue is not that she didn't pay the note. Her issue is that during the court, after Chase Bank stole her note, after a few months later, they told her, listen, you're going to have to add your impound account. You're going to have to supplement, or you're going to have to add to your monthly principal and interest payment enough money to cover the cost of your insurance and insurance?
Taxes.
And taxes. She said, I'm not going to do that. She said, I made a deal with Washington Mutual when I took out this loan that I would pay my tax and insurance directly to those entities.
Did Chase have some plan there to be the one that's paying the taxes?
Well, what they did is they went into this contest. Remember I told you about Home Sales in Florida, who manages stolen? Home Sales is paying her taxes and insurance while she pays her taxes and insurance. She's getting refunds of her taxes and insurance. Chase Bank spent 2 or 3 years, about 2 years, that when she paid her principal and interest to Chase, when she thought Chase was supposed to get the money, she pays her principal and interest, and they would send it back. So she has letters that we attach to the federal complaint. She has payment receipts and letters showing that she paid her mortgage. They forced her in default by sending her mortgage payments back. But then they turn around and Chase turns around and does a default notice, generic default notice, as if the issue was she didn't pay her premium, tax, her principal and interest. Now, that's before the federal judge right now. And when we did the pleading, when I did the complaint, I talked about that, cited the record where we had all these documents showing she had been paying her mortgage. Chase Bank, she went to the OCC with a complaint. When you complain to the comptroller or whoever when you do that, the first thing they do is send an inquiry to the Chase Bank, who's being complained of, and they require that Chase sends the homeowner a letter resolving her issues.
Right.
Well, in the course of doing that, Chase Bank admitted in the letter that she has been paying her making her mortgage payment. They talked about the dispute, but then Chase said that we had the authority to modify this agreement and make you pay your tax insurance with your principal and interest, which they don't. But the bottom line is that kind of dispute is ripe for FDIC administration, because the FDIC had her note if they're telling the truth. And one of the things the statute says is that when the FDIC takes a note in the receivership, when it sells a note, they have to stand behind the note as they sold it. And if anybody tries to change it, modify it, or otherwise, the statute says you go back to the FDIC with the complaint. And that's why a person with a FDIC note that was in receivership of FDIC can't go to a district court. They have to go back to the FDIC. And that's the name of it. So it's going to be interesting to see what the federal judge does in her case, what the next move is going to be. We hope that the judge, enforces the statute as is.
I know.
Tell you what, I thought I was in a mess, but boy.
Well, we've been in our house how long now without making a note?
2009.
And we put money aside. We've just invested in other properties. That's all.
We took the money that we were saving to pay the note. You know how you have it aside. And we just, since it's all these years, and it looked like we're going to win, Joe, we just bought another property. We bought an income property and just see what happens. But that's never been about us not wanting to pay our note. Because, everybody.
And at first, when we first bought the house, being at our age, we were on the accelerated plan with Washington Mutual. So therefore, we were making 2 payments a month because we wanted to pay our house off by 2015. And then we originally thought we were going to be able to flip it, pull some money out and do something different. But then the market fell, so we weren't able to do anything. And even the house across the street from us, which is the same as our house, the lot is larger. It just sold for $240, and we paid $350. And since then, invested about another $100,000 in that too.
And you know what? I'm naive, but in 2009, I started sending letters to Chase when I thought they were over our note. And I said, Chase, it was a philosophical letter. And I was requesting that they reduce my principal to a point where the house was no longer underwater. And I told them that equity demands.
That's the negotiation I was talking about.
Yeah.
I said that equity demanded you do this because it is not our fault that our house went underwater. It's your questionable practices, lending practice. We sat here and kept our house up, even invested $40,000 in it to get a pool and to do other kinds of investment. So why should all of a sudden we look up after doing this and our house is underwater when there's no fault of ours? Now, every time I sent that letter, every time I communicated that to Chase, they would refer me to the section of Chase that just want the mortgage payments. Now, if all of you out there that remember this, and it's even today, the only way you can go even do a modification, you have to be in default.
Right. Yeah.
Now, that means that if you want to get in there, you got to deliberately stop paying your mortgage.
Right.
Which is stupid. There ought to be modification.
That's government. That's
I think my girlfriend went for modification, but she wasn't in default.
Yeah, but I'm gonna tell you, I looked at it again because I couldn't believe the modification, the rule, the foreclosure mediation rule say you have to
no,
be
it
in
does.
default.
Never made any
Well,
sense
now
to
in
me.
California, I'm just gonna say, she lives in California. They were not in default. She's the one that told me about NACA and came out to Nevada for one of their conferences, and she had her mortgage reduced down to $1,200 a month. You know,
Wow.
so and she was not in
I
default.
know, but I'm talking about
Yeah,
Nevada.
in Nevada, okay.
Right.
Yeah.
Well, anyways, folks, another interesting conversation. I'll tell you what, it's a big pile of mud, thanks to the government, because like we were just talking about, why would the government demand that you're in default before they'll even talk to you or something? That takes away your negotiation, or makes the water a lot muddier.
Well, it puts you under pressure.
Yeah, that's what I mean. It's just, it makes no sense.
And some people just want
Makes
to
no
really stay
sense.